Well, this is a very good question because you see this a lot. A lot of times there will be a custody battle and whoever wins all of a sudden wants to change the name. It's typically the mom because the child will typically already have the last name of the dad. So in this situation, when can they do it? Well, first of all, if both parents consent, they can do it. The court can approve and order the change, but you have to realize one thing. The court's going to determine whether or not it's in the best interest for the child to have a different last name than his dad, or for the child who, all this is used to calling himself one thing, all of a sudden, call himself something else. And if the kid's in third grade, so for kindergarten, for grades 1 and grades 2, everybody's been calling him Joe Smith. Now all of a sudden they want to call him Joe Jones. And the kids are going to have to get used to it. It's going to be weird. And why do you have a different name and all that? And, I can see where it would not be in the best interest of the child, and it will cause confusion for the child to all of a sudden have a name change. So, the father's rights are going to be considered here. And there's going to have to be a very strong, compelling reason for the court to say, yeah, I hear you, but I'm ordering the name change now. The child turns of age. Child can change their name to whatever they want. As long as it's not for fraudulent reasons, the probate court will allow it. But while before the child's 18, though, expect that the court is not going to go changing the child's last name unless there's some very strong, compelling reason for it, or unless both parents agree.
248-588-3333. 248